prosecution against MPs and MLAs, either the elected representatives, will need a nod from the High Court. So the question, therefore, in this episode of Government Matters is, why is the SC getting tough on MPs and MLAs with criminal cases, and what is this entire matter about? To help us understand, Bhadra is with us. Bhadra, as you know, tracks courts for ThePrint. She tracks law as well. So do start sending in your questions right away. So Bhadra, okay, a lot of our viewers may not be familiar with what this case is, why the matter is in front of the Supreme Court.
So, Ruhi, there is a petition pending in the Supreme Court since 2016. And interestingly, it was filed by a BJP leader only, who's also a lawyer. And in his petition, he had sought a prayer to disqualify or debar all the political leaders facing criminal prosecution. But since the court technically cannot issue such kind of a direction, so the court decided to kind of monitor the pending criminal cases against elected and former MPs and MLAs. Now, in that process, what they did was they kind of instituted a mechanism to fast track disposal of these cases, and during various dates, during the hearings and arguments, a consensus emerged and a decision was taken to actually set up courts, exclusive courts, to hear cases pending against elected representatives. And in that process, only 12 courts were set up across the country in 9 states, and all the cases that were pending before various courts were transferred to these specific exclusive courts. And since 2016, the court has been monitoring the progress. Today's hearing actually happened after, say, about 6-7 months. Due to the pandemic, the matter could not be taken up. Last, when it was taken up in November 2020, at that time, the court had actually sought, a status of cases pending in various courts, various states. The status reports were asked from various high courts, and the central government was also scheduled to submit data on the number of cases registered by CBI and ED. These two, as we know, these two are central agencies. So it wanted to know how many MPs or MLAs are facing cases registered by the CBI and Enforcement Directorate. Now, we have a senior advocate, Mr. Vijay Hansaria, who has been assisting the bench in this matter and has on various occasions submitted status reports regarding the status of cases pending. And in his latest status report, he pointed to an increase of about 700 cases, and pointed out that how the cases in a way jumped between 2018 and 2020, actually, last two, between 2018 and 2020. So that was the latest data submitted by him. And in his report, Mr. Hansaria pointed out something which is very interesting. He said, and this is a trend which we have also noticed, he highlighted certain withdrawal applications filed by various state governments. And interestingly, these withdrawal applications means withdrawal of cases, withdrawal of prosecutions. And these withdrawal of cases is actually vis-a-vis the members belonging to the ruling party in these particular states. And he said that this is a worrying trend, because it so happens that when a party comes into power, the first thing which they do is actually start moving applications to withdraw cases against their own leaders, against members of their own party. So he said that, this really needs to stop. He gave instances, he cited cases from UP, from Maharashtra, from Karnataka, from Uttarakhand, to stress upon this point. And on his prayer, the bench led by Chief Justice of India, Justice N.V. Ramanna, issued this direction to say that no withdrawal of prosecution or criminal case would be allowed without the High Court's permission. Now, why the High Court? I would just like to point this out as well. As the matter progressed, the Supreme Court of India had actually directed the respective state high courts to take cognizance of the cases pending in their respective states and start monitoring on regular basis, because it is not possible for the Supreme Court to minutely track the progress of such cases. So it kind of in a way asked the high courts to do it. So that is the reason why the court has now said that these cases should be withdrawn only with the permission of the High Court.
Right.
So as per the law, it is actually the trial court which decides, but after today's order, cases particularly pending against MPs and MLAs cannot be withdrawn without adequate permission of the High Court.
So it makes it tougher for the party in power to sort of dole out favors to its own by dismissing cases, withdrawing cases.
It does, because it is, because I mean, I would not really say that these cases can be manipulated, but it often happens that, trial courts do get under pressure. I'm not making any comments or remarks against but I'm just talking something which is very general and in practice and is experienced also, that trial courts do come under pressure, and that is probably one of the reasons why the Supreme Court now says that it should be under the High Court's monitoring.
All right, okay. So let's begin with this question from Gopinath Vijay Kumar. How much progress has been made, or how effective are the special courts for representatives?
No, so that is another aspect which was pointed out by Mr. Hansaria in his latest report. See, as we all know that there are only 12 courts which were constituted in 9 states. But as per Mr. Hansaria's report, more than 4,800 cases are right now pending against MPs and MLAs.
Right.
And it's quite a lot of, I think, burden for these exclusive courts. So as per his recommendation, we should have one special court in each district now, if we want to really fast track the disposal of these cases. So I won't say that it hasn't made progress. It, of course, having an exclusive court has made a little bit of difference, but not to the effect which all of us would
intended.
really. Yes.
Right.
Yeah.
All right. This is from Arpit Jain. Do you think there should be a formal examination to be a qualified MP or MLA? We have that for civil services. Why not being a parliamentarian? Okay, this is a radical thought. I think the biggest exam they face are the elections through which they are elected.
That's right. I think, Ruhi, when we talk about this case, one of the main reasons why the court actually decided to intervene in this matter is probably because, we have seen in the past as well that the Supreme Court has passed several directions with regard to decriminalization of politics, bringing in electoral reforms. So this case is actually similar to those cases as well. So I think the step taken by the Supreme Court is actually intended to kind of usher in some sort of electoral reforms, because all of us know that criminalization of politics is a very big issue, and the number of MPs having some sort of a criminal background is kind of increasing.
Right.
And this is not the first time that the Supreme Court has spoken about this worrying trend. It has happened in the past as well. And several reforms have actually, taken place due to the top court's intervention. So this is kind of, I see this case as one of those where, the judges or the court is really trying to kind of
clean up the system.
Yeah.
Okay, so in fact, Hill has a similar comment, this viewer, who says people with any criminal record should be barred from contesting.
Right, because in fact this PIL, the main prayer of this PIL is that, that people with criminal backgrounds should be debarred. But then the court cannot give this kind of a direction because the law doesn't permit so, and all of us know that courts cannot write or bring about a law. They can surely interpret it, or give certain suggestions to the government. So
right. Tanveer Panjwani, apart from declaring pending criminal cases against MPs and MLAs, shouldn't the time from when they are pending also be declared so that the judiciary is also held accountable for the delay?
So, well, that is another another debatable issue, that normally people say that, judiciary is accountable for the delay. But I would like to point out that in his report, Mr. Hansaria has actually spoken about one of the main reasons for delay in such cases, and suggestions have actually been made to the court to tackle this. And the reason is, the inability of the witnesses to come forward and depose in the court. See, often what happens is these cases are pending in districts in far-flung areas, and in most of these cases, witnesses are also required to travel long distances, and they don't want to take that kind of a risk. They don't want to make that kind of an effort. So to kind of overcome this problem, the amicus has advised the court to install or to have video conferencing facilities in all the special courts that would be set up to hear these matters.
Right.
So that the witnesses do not need to travel, and wherever they are, they can depose from their respective homes
locations,
or probably go to a particular center from where they can be connected through the video conferencing facility with the court. And second thing which Mr. Hansaria has suggested is, to have safe and secure witness rooms in courts, because we often know that witnesses tend to get threatened, intimidated. So the idea is to have a safe and secure environment for them, so that they come fearlessly and depose and then go back without their identity becoming public.
Right.
Yeah.
Okay, Vipin, who's a member of the Print's YouTube community, voters need to be more alert about candidate records rather than relying on judicial activism to come to rescue all the time. Political parties will always give priority to winnability. So, how much can the courts intervene? There has to be a greater, sense of voter awareness and ability to sort of tell the voter that, look, this person has a criminal record.
No, of course. In fact, today the Supreme Court has delivered another judgment in a different case. It is not related to this matter, where the Supreme Court has actually given directions to the Election Commission of India to create a mobile app, so that there is information regarding all the candidates having criminal backgrounds. Now, this judgment is actually, is a follow-up to an earlier verdict of the Supreme Court, which was delivered last year in 2020, where the Supreme Court had directed all the political parties to kind of make public information regarding their candidates, especially those candidates who have criminal background.
Right.
And this was to be done within 48 hours of deciding whether a particular candidate will fight the elections or not. And in fact, the political parties were also required to provide information to the voter as to the reason why that candidate has been selected to contest. So, and this was done, keeping in mind that the voter is primary, and the voter has a right to know before expressing his freedom of speech and expression, which is right to vote.
Right.
So various directions have been given by the Supreme Court, but then it is up to the political parties, to follow it. In fact, today's judgment by the Supreme Court comes on a contempt petition filed by a lawyer, pointing out that how all the political parties violated this 2020 judgment in the Bihar Assembly polls. So, time and again, the Apex Court has been really talking about the need to decriminalize politics, but then ultimately it's up to the political parties as well as the government in power today, because there are no set laws actually to deal with this problem.
Right.
It is only the directions and the judgments given by the Supreme Court, but there is no law per se. So, in fact, in today's judgment also, the Supreme Court has pointed this out, that, we hope that the government in power today deals with this menace, because it is a menace, criminalization of politics is actually a menace today.
Right.
Yeah.
All right. Okay. Shankar Bish, when any state withdraws a case against its MP or MLA, what happens to the trial or investigation that is done till then? It all goes in vain. What about the time and resources consumed during these investigations?
Yes, it definitely goes in vain, and that is one of the reasons why most of the times withdrawal of cases is fought. And in fact, recently the Supreme Court delivered a judgment, in connection with the ruckus that took place in Kerala Assembly in 2015. And in that, while disallowing the Kerala government to withdraw cases against its own leaders, the Supreme Court has actually emphasized the point that withdrawal of cases can only happen if it is in public interest. And it has gone ahead to give out guidelines for the public prosecutor as well as for the trial courts, and laid down grounds on which such kind of withdrawal can take place. I completely agree that withdrawal of a prosecution is definitely a waste of time, and especially of the investigating agencies,
Right.
because in several cases we have seen that the withdrawal application is filed after the charge sheet is filed. So filing of a charge sheet means that an investigating agency has actually completed its
Right,
probe.
and spent a considerable time doing it.
Exactly. And, even the trial court's time is equally important, because they really dedicate a lot of time in hearing these matters. If this case has to be withdrawn, then it should be withdrawn at the earliest. So yes, it is there, but hopefully after this recent judgment, things should streamline and become much better.
All right, if you want more details of this judgment, if you want more details of what the court said today, you can log on to our website, theprint.in, to read Bhadra's story. It will perhaps help you with an even better understanding of what transpired. Thank you so much for watching Government Matters and for sending in your questions. Keep subscribing to our YouTube community. Become a member of our YouTube community.